Good evening and welcome to the JAJ Network. The only thing missing from this news is Ron Burgundy himself, but don't worry, we got an upgrade. Tonight we are going to dive into some recent stories regarding employment law. Now for our first lead story, we'll send it over to Jack.
And for this next story, we will be heading down south to the Georgia Supreme Court for the employment-related injury case of Ocmulgee EMC versus McDuffie. Now the roots of this case began all the way back in 2002 when Casbian McDuffie injured his right knee at a job at Eastman Youth Development Center and had undergone 3 knee surgeries by July of 2003. In March of 2007, McDuffie applied for a job at Ocmulgee Electrical Management Company, but in the process he failed to disclose his past knee injury at his previous job, as this information would have shown McDuffie to be unable to perform the job for which he was applying for at Ocmulgee EMC. In September of 2009, McDuffie stepped into a hole while at work, re-injuring his knee, and EMC began paying him workers' compensation benefits. McDuffie was fired, and his workers' compensation benefits were suspended in March of 2010 when the company discovered he had falsified part of his application in saying he could physically do the job. His benefits were shortly reinstated following a recommendation by a physician for an additional knee surgery. But once his knee was in good condition again, the benefits were once again suspended. McDuffie then sought reinstatement of the workers' compensation benefits and had a hearing before an administrative law judge, and his request was ultimately denied. He appealed the decision, and the case snowballed all the way to the Georgia Supreme Court. The issue at hand here is whether an employer has to show the availability of suitable employment to justify cutting off workers' compensation after already establishing the fact that the worker's previous work-related injury is no longer the cause of the employee's disability. The Court of Appeals ruled in favor of McDuffie, saying that EMC could not suspend workers' compensation benefits on an improvement in McDuffie's condition unless EMC showed that McDuffie could return to work because of that change and that EMC had offered him suitable employment. In October of 2017, the Georgia Supreme Court overruled that decision by asserting the appeals court had made a mistake and sending the case to the administrative law judge court to determine if the employer demonstrated suitable employment for McDuffie. Let's send it back over to Laval for our next lead story.
Jack, down at the Abercrombie & Fitch store, there was an employment discrimination case. At the store, there is a look policy that employees must comply with in order to be hired, as their clothing and look must reflect the store's vibe. When a prospective employee wishes to have an accommodation to the look policy, they should inform the interviewer, and the interviewer then sends a request to the HR department for review. A young woman named Samantha Eloff, a practicing Muslim who wears a headscarf, failed to ask her interviewer for an accommodation to the look policy, and her interviewer did not send the subsequent request to the HR department. The interviewer did inform her manager about Eloff's headscarf, and as a result, the manager told her to lower Eloff's potential employment score, and as a result, Samantha was not hired. The Equal Employment Opportunity Commission sued Abercrombie on Eloff's behalf and claimed that the company had violated Title IX of the Civil Rights Act of 1964 by refusing to hire Eloff because of her headscarf, which is part of her religion. Abercrombie argued that because she did not inform her interviewer about the headscarf, Abercrombie could not be held liable for Title IX discrimination. The case made its way all the way to the Supreme Court. The fundamental question that the Supreme Court had to answer was whether or not an employer can be held liable under Title IX of the Civil Rights Act for refusing to hire an applicant based on a religious observation if they did not have direct knowledge of the religious practice and the need for an accommodation. The Supreme Court ruled that just because Abercrombie was not directly informed, they could reasonably tell that she was wearing a headscarf and counted that against her, and therefore was discriminating her on the basis of her religion, a clear violation of Title IX. In the future, the job applicant in an employment discrimination based on religious affiliation must only show the need for an accommodation was a crucial component in the company deciding not to hire her. And obviously, in this case, Eloff was discriminated against as her employment score was lowered to the point where she wasn't hired because of her headscarf and her religious practice. The precedent set here was an employer can still be held liable for discrimination if they refuse to hire an applicant based on religious affiliation, even if they do not have direct knowledge of it. Discriminating based on religious practice is illegal, regardless of whether or not the employer knew about the practice. Now let's send it over to Joe, who has some news from the hardwood basketball courts of Brandeis.
Andrew, the Brandeis judges will be lacking leadership after head coach Brian Meehan was dismissed from his coaching position. This dismissal comes in the wake of multiple students at the university filing discrimination complaints against the head coach. At a time where major universities have been facing massive scrutiny, such as Michigan State, Brandeis tried to respond as quickly and efficiently as possible to these complaints. According to a statement released by the university, Coach Meehan's complaints range from preferential and discriminatory treatment, unprofessional behavior, and racially biased harassment. This dismissal is a big deal for the basketball program, especially due to the fact that Meehan is the second winningest coach in the university's history. However, hats off to the university for correctly responding to this unacceptable behavior. Whammy!
Although a bit more dry, now we're going to enter into the New York partnership dissolution case of Conjal versus Malfitano. The two parties entered into a written agreement to form the Poughkeepsie Galleria Company partnership to own a 1.2 million square foot shopping mall in 1985. Mark Malfitano, who was a general partner and the defendant of this case, owned 3.08% interest in the partnership. In 2006, Malfitano told his partners that he was dissolving the partnership because of a breakdown in the relationship with the partners. The other partners brought the case to court, saying Malfitano wrongly dissolved the partnership by breach of contract and sought damages. The New York Supreme Court sided with the plaintiffs, as they determined that the partnership was not an at-will partnership and thus could not be dissolved without violating the partnership agreement. On January 10, 2017, the case went to the New York Court of Appeals. Ultimately, the Court of Appeals decided the lower courts erred in applying the New York Partnership Law 62(1)b in deciding that the defendant violated the partnership agreement. Now, this law says dissolution is caused by the express will of any partner when no definite term or particular undertaking is specified. While they failed in taking that clause into account, the appeals court decided that the New York Supreme Court correctly concluded that the dissolution was in fact wrongful, as the partnership agreement was written and contained a provision that prohibited a single partner from dissolving the partnership without a majority vote. Let's swing it back over to Andrew.
Thanks, Jack, for that thrilling story. Big-time phone company AT&T attempted to merge with Time Warner Cable, owner of DirecTV, to form a super corporation. The government blocked the merger because it felt the merge between the super TV and phone companies would be able to charge unfair prices, driving up the cost for consumers by creating an unfair advantage for the super company. The government claims that the combined company will have the leverage to demand high rates from content from other companies other than that of AT&T, ultimately driving up the cost for consumers. The Justice Department seems to be depending heavily on sealed and redacted documents in their efforts to block the merger. The decision has not been released yet, but should be coming within the next few months. In my personal opinion, I believe that the merger will be blocked because of the unfair advantage that will be created for the super company.
Big News Drew does it again with another fantastic report. In other news, the University of Vermont is under scrutiny for an employment discrimination case. Cindy Ruscher was a former information technology specialist at the University of Vermont. And while there, she claimed she was excluded from certain job opportunities and paid less than her male counterparts, which would be in violation of the Equal Pay Law. Ruscher was ultimately fired 4 months after the complaint was filed, and the university claims it was due to budget issues. The court has initially dismissed Ruscher's central argument that she was denied equal pay. However, this is not the only grievance against the university, as Ruscher has a whole list of complaints that she is seeking pay and other damages for gender discrimination, hostile work environment, illegal retaliation, breach of contract, emotional distress, defamation, negligent hiring, and unjust enrichment. Ruscher's trial will begin on April 6, 2018.
A man who attempted to acquire workers' compensation after he was brutally attacked by a coworker on the job has had his request denied. Two fellow employees who had not shown any negative behavior toward one another prior to the incident got into a violent confrontation after one of the employees conducted an internet search and found that his fellow employee was a registered sex offender. The attackee had his request for workers' compensation denied by the Nebraska Appellate Court. The court cited that because the assault had not occurred as a result of the employment, but rather the employee's private life, the company was not liable for damages. Bye now.
So long.
Thanks.
Whammy!